Thank you so much, you who is still tuned in on Church of Uganda Family TV. Good morning, family. And here we are with Issues at Hand. Now, Issues at Hand on Good Morning Family is brought to you by Protea Hotel by Marriott Entebbe. So, if you're looking for a place to be, Protea will give you comfort at its best. Therefore, you can make your reservations on the numbers that you see on your screen. Edrine, Osteen, Mukalazi this morning are sitting in for Bruno Edgard, who is unable to be with us. He's battling with his health, but we pray that he's healed in Jesus' name. Now, today we are looking at the plight of workers, especially when it comes to creating a conducive workspace, a conducive environment where both the employer and the employee will enjoy the place of work. And just to remind you that last week, on Wednesday, that was the 24th, the Parliament passed a bill, and this Employment Amendment Bill 2022 was intended to improve on the rights of casual workers, basically. Although they were giving more rights to the ministry as well. So the minister, according to this Amendment Act, will have lots of powers. That is the Minister of Gender, Labor and Social Development. But what is most important is that you can no longer hire, according to this amendment, you can no longer hire a casual worker for 6 months without giving them a contract. And in one way, it is a good one, because you realize there has been a lot of exploitation. But then we should also put in mind that we have people, even the professional workers, who work for years and months without contracts. Now, I believe, as the law states about contracts, very many employers have not embraced this issue of contracts for the reasons they know very well. But with us is someone who is going to actually take us through most of these things. And I believe by the end of this show, we shall be able to have answers to the many questions. So you who is working without a contract, you'll be able to either go and demand for this contract or find what to do. And with us is none other than Mrs. Nabirye Susan, who is an executive member of Legal Aid Department of Central Organization of Free Trade Unions. But she's also a panelist representing workers in the industrial court. So we know we have the right person we are talking to. Mrs. Nabirye, you're most welcome to Issues at Hand this morning.
Thank you so much, Edrine.
Yes, kindly greet viewers who are really expecting to hear from you.
Good morning, family. My name is Susan. As Edrine has rightly said, I'm happy to be here this morning.
We are also happy to receive you this morning. Now, someone would be asking about when, especially when it comes to COFTU, that is Central Organization of Free Trade Unions, who should be a member, who qualifies to be a member, who should not be part of COFTU, and what does COFTU do generally, especially for the workers?
Thank you, Edrine. COFTU is simply the Central Organization of Free Trade Unions. Central Organization of Free Trade Unions, meaning it is a labor center that takes several other unions. Okay, several other unions are affiliated to it. Yes, so to be a member of COFTU, you should be a member of one of those unions. Okay. That are affiliated to COFTU.
Okay.
Yes.
So how is COFTU now helping empower these member organizations that are affiliated to it?
COFTU helps the members affiliated to it through constant provision of trainings to their members, the members of the affiliates. Okay. And we do that regularly. And we always come in as COFTU. The center always come in and is always available for a union that has gotten any challenge yes, at the workplaces or in their person or in their individual union, issues that they may be finding administratively, the center always comes in to facilitate and assist them in the better running of their unions.
Now, getting back to our topic, which is creating a conducive work environment where both that, because it is possible to have employers not enjoying their workplace, and some of these reasons could be caused by the people they have hired to take up some responsibilities, and vice versa. The employees as well might feel insecure or might not really enjoy what they're doing, and most of us at some point it could be caused by maybe the employer or the hiring body. But to start with the employers, I know most of these trade unions come out to fight for the rights of workers. Whoever fights for the workers of the employer?
Thank you. That's a very good question. As we have workers' representatives, we also have employers' representatives.
Okay.
And that is the employers' organization. Okay. Which is actually equally represented in the industrial court as well. We have workers' representatives on the panel in the industrial court, and we also have employers' representatives.
Okay.
That organization is called FUE, Federation of Employers. Yes.
So
Federation of Uganda Employers.
Uganda Employers.
Yes.
In other words, if any employer has any issues, they can now go. They can go through this federation
They
to
are
access.
meant. They are meant to address or take their issues, work with FUE, if I may put it in brief, because employers organization, we usually call it FUE. So they work together, and this FUE also is like, for example, COFTU. They also have affiliates. Employers affiliate to FUE. So that is how they work.
Okay.
Yes.
Now, getting back to the workers, which could be our main target this morning. We've had very many strikes and demonstrations of very many workers through their trade unions. For example, we've had, especially in the recent past, we've had very many people in the medical sector striking, and until when they give up, sometimes the causes of the strikes are not even worked on. We've also had teachers strike. I don't know whether there's any plan of them striking, because they normally do that at the beginning of the term. We've not had UNATU come up with any statement of the strike, but we've also had them. And then until when they're tired of striking, they go back to work without their issues being addressed. Why do you think are these strikes even meaningful in any way? Do they still make any sense even when we have freedom of expression in Uganda? Is this really a realistic way of expressing their challenges at work?
Thank you. Strikes are legally recognized under the law. And it is meant to bring an environment that when a worker or when somebody or a group of people are unsatisfied with the conditions, and they have tried all other measures, okay, of ensuring that their issues are worked on. After they have failed, if they opt for a strike, it is legally recognized under the law. But it has got to come in a way that is also acceptable legally.
Yeah, I look at all this, and most times, especially the teachers, the doctors have striked the right way. But I mean, they've gone back to work without these issues being addressed, simply because they realize it is no longer meaningful to strike. Could this be really a reasonable way of expressing, as you who listen to the workers, could this be a reasonable way of expressing your challenges at a workplace anymore?
Strikes to a certain extent reasonable, though they may not bring about the result the way you expect or in the timing that you expect. For example, the teachers have been striking, and to a certain extent they have achieved. The salaries of teachers have started being revised, okay, because the science teachers' salaries are now better than they were. And all this is because they have been speaking and somehow striking, okay, showing the public that they are unsatisfied.
And now the challenge with this is that UNATU, as UNATU, we could say failed out on this. It went out of their hand because you realize that there was a different now trade union that came up. I could call it a trade union or a workers' association for science teachers, which through which the ministry was now able to increase their sciences. So what about these others who are not part of the other science as our science teachers association that UNATU now represents? Because UNATU disowns this association.
They are all teachers, and it depends on who is giving what you want to receive.
Okay.
How they make their choices of where to start from. And we can say that UNATU has also achieved in a way, though the payment started with the science teachers. We are sure that they will also be able to receive something additional to what they are receiving right now.
Okay, so we look at now the labor laws in Uganda. To what extent have these laws been respected by the employers?
Edwin, to what extent the laws have been respected by employers? I'm going to look at. I want us to look at the implementation of the laws.
Yes.
And I will ably do this by as a panelist of the industrial court.
Yes.
Because we are the implementers of the labor laws. We are the enforcers of these labor laws. So, in my view, it's good that we have the labor laws, and indeed they are very good laws. But as you know, implementation of the law does not come in a very short time, because people need to get acquainted to them, appreciate them, and be able to devise means of implementation within their organizations. Some employers have tried to do this and are trying to do it. For example, the issue of availability or provision of contracts for the worker, issues of occupational safety and health in the workplace, issues of the general work environment. You know, some employers have tried to ensure that they adhere to the law, but so many of them are still adamant, and it is still a challenge, because we find it as we deliver the rulings in the court, as we look at the files and we peruse what has transpired in a case. You realize that there is still a lot that the employer has to do as far as appreciation and implementation of the labor laws is concerned.
Now, the question is why? Why do you think most employers are still adamant?
I would think that what causes the employer to remain adamant, I would first put myself in the shoe of the employer. They keep saying that the environment, the costs of living are very high, so are the production costs and maintenance and all that as an employer. So they keep finding ways of dodging, dodging their responsibilities, because they think they also need to remain with something called profit, of which we cannot be able to ascertain. So that could be one of the reasons that the employer is giving. But also, I have realized that many of them are simply stubborn. Yes, They are simply stubborn.
I love that statement, stubborn. Stubborn in a sense that they provide a false data, or they are not, they have deliberately refused to comply.
Precisely.
Okay.
They do not want to comply with the laws, and the worker, as a person who is depending on them, is the one to suffer. Yes.
So, what measures are there to see that workers who are not complying? Because of recent, we've had very many amendments, including forcing employees to pay NSSF for their workers, and you realize that up to now there are companies that have deliberately refused to pay NSSF, if I can start with that, and then plus the other benefits that are highlighted in the labor laws. But is there any tracking module? Is there anything that you are doing to see to it that at least these employers may be tasked or punished in any way, or maybe penalized for not complying? Because these are laws, these are national laws that are supposed to be respected.
I understand. You see, NSSF is supposed to benefit the worker because the remittances are basically for the worker.
And the highest percentage is supposed to be paid by the employer.
Yes, by the employer. And what happens is that there are employers who are doing it, and there are those who are dodging to pay the money to remit the NSSF on their side on behalf of the worker, or for the purpose of the benefit of the worker. It is important that as workers' organizations, we work together with NSSF probably to ensure that implementation of NSSF remittances is done.
Okay.
Because that is one of the benefits that a worker really has in this country.
So still about NSSF, where does this worker go to report? As a worker, if I realize that my NSF has not been remitted, or maybe my salary has been underdeclared. For instance, I earn 200,000 shillings and my employer says I earn 100,000 shillings, simply because they want to reduce on how much they are supposed to remit as a percentage for my NSSF remittance. Where should this worker go to? Should this worker go to these trade unions, or they go directly to NSSF, or they go to the industrial court?
There are options. A worker may choose to go to NSSF direct if they are within the reach, or they may go to report to the nearest labor officer about the issue, because cases that come to industrial court are cases that have been worked on by the labor officer first. So they may choose to go report to the labor officer or to the union direct, those who can access or are members of the union. So that is how a worker is supposed to ensure that their NSSF remittances are done by their employer.
Okay.
Yes.
Now, let us shortly talk about the amendment bill, the Employment Amendment Bill 2022 that was passed by the Parliament of the Republic of Uganda last week, which gives, I'll not look at the powers given to the Minister of Labour, but we look at the controversies in this law, whereby some legislators were saying this bill will now make an employer overwhelmed with the casual workers, because basically most of the amendments were with casual workers, and a casual worker is required to have a contract, especially if they have been at a station for a period of 6 months. And then we also have the 3 months probation that the law has been providing, and you realize that issues have come up with this probation, whereby some people are not even being paid in that probational period. So do you see any fruits of success out of this amendment bill? you as people who deal with workers' trade unions?
Edwin, as far as the casual worker is concerned, I think so. We would see fruits, because by the fact that a worker is not supposed to work beyond 6 months without a contract of service, I think it's good enough for some kind of security to this worker as they work, as they do their work, that they can be sure that after 6 months they will receive a contract which will act as some form of permanency of work.
What happens to a situation where an employer hires you, you're a casual worker, and then they terminate your contract after 5 months? You've diligently worked for them for the 5 months, and then the 6th month they terminate your contract before you qualify for a contract. They terminate you, actually. They terminate you before you qualify to have this contract. Is there a way this worker will be, this worker's rights will be fought for?
You see, Edwin, we cannot. An employer-employee relationship is a delicate one. We have to appreciate, and also appreciate the fact that you cannot force it. You cannot force it. So if an employer terminates the employment of a worker within 5 months, ensuring that by the 6th month he's out of the way, okay, of providing the contract, it is something not good. But currently, as long as he has been paying them, and they do not have salary arrears or wage arrears, it is a little bit complicated and complex on how the rights of that person to remain in that workplace are concerned.
What about if my wage or whatever I can term it has not been paid for a period of 2 months or 3 or even 1, and I don't have a contract, a valid contract? Where can I report with proof that I've been a worker here without a contract?
Under COF2, we have a department called the Legal Aid Department. We handle issues concerning workers, complaints of non-payment of salaries and wages, and such complaints of short periods of work that haven't been paid are received, and we do begin with what we call mediation meetings. Okay, we get to know where the employer is, and we write to them, and we call them for mediation meetings, and many of them have been very successful, because when there's a third party, okay, on the side of the worker, or in any issue, there's always a hope for success. So we talk to the employer, even if the contract is not written. Even unwritten contracts are recognized by law. By the fact that, by the practice that I have been coming to work, and I have someone else that can support that position. Okay?
Someone who has been seeing you work?
Yes.
Okay.
Someone else can support the fact that I have been working, I've been doing this, even if there is no written contract. It can be recognized and enforced to a certain extent.
Okay.
Yes.
What about in circumstances of contract termination?
Edwin, the contract termination? After what period of time?
No, I mean, my contract is still on, and then out of the blue I come to work, and my employer tells me we can no longer have you here for whichever reasons. What happens? Should I still go and claim? Should I? What am I supposed to do to fight for my right of employment? Because if I have a valid contract, then it means I qualify to be a worker of that particular company until when my contract is expired.
You're meaning contracts that are terminated before they end?
Exactly.
Well, as I said before, we cannot force a relationship between a worker and an employer, but, and I will repeat, but there are conditions that should be fulfilled before termination takes place.
Like?
Notice of termination.
How long should this notice be?
The Employment Act provides for the notice periods that are supposed to be given to a worker before his termination is effected.
Okay.
So if you have worked for, say, 1 year and 1 year, okay, for a period that is at least 1 year, you're entitled to like 1 week, 1 month notice. Okay. So depending on the period of time, if you're 10 years and above in the workplace, your notice period for your termination should be 3 months. Okay, they should tell you 3 months before that we are intending to terminate your contract. Okay, and the reasons should be clearly stipulated for that kind of action. Yes.
Then what happens if this time it is the employee who could be by some reasons frustrated at work, and so maybe they feel they should quit? How early or how soon should a resignation letter come in? According to the Employment Act, employment laws, labor laws.
There is still need for a notice period to prepare the employer for your resignation, and it is normally 1 month. Yeah, at least 1 month. You inform someone that I intend to leave, and then you go. And definitely that has also conditions, it has implication that when you go and it is you who has caused your departure, okay, or you, out of your will, there are certain privileges that you may not receive.
Yeah.
Yes.
Like?
Terminal benefits, some of them you may not be able to get.
What are these terminal benefits? Because someone out there might really be wanting to know what these terminal benefits. Maybe they have already made up their mind to resign, but when you talk about terminal benefits, they should know so they can sit back and wait for these benefits at the end of their contracts.
When an employee is terminated, they are expected to be repatriated to wherever they should be going after staying at this workplace. They may want to go back to their home villages and do other things. So the law provides for repatriation. Okay, there is a formula for it. You also are entitled to. You are entitled to leave pay in case you have not been receiving it, and that you have been applying for it. Okay, been applying for your leave and you've not been receiving it, you can claim for it at the end of the contract.
Okay.
Yes. You also for government workers, they know what they receive. They receive the pension and their retirement benefits. So if when you terminate the contract, or when you want to leave the work before the end of the period that is expected, you will not get everything.
So you who was planning to quit, sit back, relax, and wait for these benefits. So we look at a situation where we have a lot of challenges, especially because we have privileges that are being highlighted in the Employment Act. But you realize that very many workers, like you said, they stubbornly violate them. For example, leave and all those. You realize that some mothers are not even given maternity leave, or if they're given maternity leave, they're not given the recommended maternity leave. So you realize someone has only 1 month between giving birth and coming back to work. So someone works up to this week when they expect a child the following week. Or you realize that if they're supposed to be, they're not even given any leave throughout the year and at all. So maybe just to tell us some of the basics in this employment act, so that people can know their rights as far as employment is concerned.
I will start with where you have ended the leave, maternity leave. Maternity leave is provided for under the law, and any mother is meant to receive leave from their employer. But as I have said, you need to apply for it. We need to develop a culture of applying for leave, because court has made a decision or decisions to the effect that the worker should have applied for that leave if they are to claim for it.
Yeah, I thought the employer just looks at you and then they will know that you need a leave. Well, we are taking a short commercial break, but just remind you, we have just 5 days to the Uganda Matters Day celebrations, and this year's celebrations at the Anglican site have been organized by the dioceses, the 10 dioceses that make up the Eastern cluster. Those are Karamoja, North Karamoja, Mbale, North Mbale, Sebei, Soroti, Kumi, Bukedi, Busoga, and Central Busoga. So we encourage you to come in big numbers as we celebrate those who died for their faith. Now, we are taking a short commercial break. We shall be returning soon. Protea Hotel by Marriott Entebbe. Comfort and luxury at its best. Now, Protea Hotel by Marriott Entebbe sponsors Issues at Hand. So, Issues at Hand is here because Protea has made it be now. Protea will give you the best of what are you planning for a wedding? Are you planning for a conference? Are you planning for what are you planning for? Do you want to have holiday with your family out of your home? Protea Hotel is the answer. Now you can make reservations on the numbers that you see on your screen. We are continuing with Issues at Hand on Good Morning Family with me, Edrine, Osteen, Mukalazi this morning, and we are looking at creating a conducive environment for both the employer and the employee. You know, sometimes, like we said earlier, that it is very possible for employers to be in places where they do not enjoy, where they're not comfortable, especially with the way workers react to certain things. You know, you give them discomfort, and yet sometimes they are hesitant when it comes to terminating you. Now, with us is Mrs. Susan Nabirye, who is an executive member of the Legal Aid Department of Central Organization of Free Trade Unions, but she's also an industrial court panelist representing workers. So we are talking about issues of workers. Before the break, we are talking about some of the rights that a worker is entitled to, especially when it comes to these laws, the labor laws, or even in the Employment Act. And one of them was the maternity leave that she told us about. But most importantly, if I can mark her words, she said, you need to write. So it's not a guarantee that the employer will look at you and then they know, oh, this person needs a leave. No, you need to put it in writing. And she was emphasizing that develop a habit of writing. Now, Susan, we want us to wind up with this particular one where you were telling us that employees should develop a habit of writing. So you shouldn't take things for granted. I think sometimes we grumble because we think our employers know that we need certain things.
Yes.
So we continue from there.
Okay, that's very right. As a worker, there's need to be diligent and vigilant in pursuing our rights. Yeah. So the fact that the rights are there and they exist, do not take it for granted that they will be given to you. Sometimes you need to step out and be able to agitate and assure your employer that you're aware of these rights. That's why awareness is really very important when it comes to rights of workers.
Okay.
Yes.
So which other rights can we talk about besides the maternity leave and the leave besides the leave?
Yes, I will first go back to maternity leave.
Okay.
Well, maternity leave
Because that is really an issue.
goes hand in hand with paternity leave. We also have paternity leave for 4 days. As a father, of a baby that has been born, you also have the right to get your paternity leave, okay, to go and take care of the little one that you have received. So that should also be taken into consideration. They are important 4 days for the fathers to be able to have a rest. And
isn't that really too little? Why not at least 2 weeks? Only 4 days.
We shall be able, I think the law will be amended.
Okay.
That also depends on how you, as I told you, that we have to get out of our comfort zone to make sure that we tell the lawmakers that there are things that are not balancing here and there. So you talked about you want us to highlight on other areas where
basic rights workers have at their places of work.
The basic rights include the right to be paid, your remuneration, okay, on time, the right to sick leave. And when you're sick, when a worker is sick, is entitled to receive leave, and for the first 1 month, you should be paid all your salary or your emoluments in that regard. Then there is we also have the right to the period of the right to a weekly rest. A worker is supposed to rest every week. Give them some kind of rest, because in the whole week the law says the worker should be working for 48 hours in a whole week.
In the whole week.
Yes, legally that is what the law states, and it's not about making someone to work all through without resting. Give them some kind of rest and they relax. It is also meant for their mental health and physical health as well.
Okay.
Yes.
And then we have now another big issue, and this is about people who work in factories, in construction companies, still as casual workers. As the Parliament was passing this Amendment Act, one of the Member of Parliament that represents workers, that is Honorable Rabashaija Margaret, said that you realize that some factories have even gone ahead to hire third-party companies to bring for them these workers. Why? You're in a place, but you're working for an agency which does not, so the factory does not directly is not directly in charge of you. In other words, if you get any injuries at work, the responsibilities are shifted from the factory and now to the party, the agency that hired you to work for this factory. And you realize that we've seen very many reports of people. I was working for a steel company and then my hand was chopped off. I was working for a construction company and then a grader did this. A lot of stories have really come in. And who fights for these people?
Edrine, who fights for those people?
Yes.
The law is being amended to the effect that responsibility that they are evading, the real employer is evading and pushing it to the contractor, okay, should not exist. They should take full responsibility of this worker.
The contractor or the hiring firm? I mean the factory or the hiring firm? Who takes the responsibility?
The factory.
The factory?
Yes.
But what happens? How does the law state it? Because the factory will say, even when we are paying, we do not pay you directly. So your salary doesn't come from our accounts. We pay this company, ABC, and it is that company that pays you. So it is directly involved. It's directly responsible for all this. But I think sometimes this happens because most of the people are ignorant. They don't know how to fight for their rights. So it is from here that I want you to help someone there know who is responsible in moments where you get injuries or you get issues at a place of work, even when you're not directly employed by that particular company, but you've gotten this injury from that very place when you're doing their work?
The person or the person who's responsible is, of course, your employer, and we are trying to make sure that we do not have this responsibility pushed to another person. Let the relationship that exists between the employer and the employee, where we have a middleman called the contractor. The contractor should take full responsibility also, because they are benefiting from my effort as a worker. So they need to be responsible for whatever befalls me. Yes.
Okay. So are there any privileges that the law stipulates that I should benefit?
Edwin, privileges in what sense?
I mean, if maybe I've gotten an injury from a place of work. I work for a construction company. I've fallen from maybe the fourth floor down. So besides maybe taking me to the hospital, what other privileges am I supposed to receive? Should they still pay me even when I'm in hospital? You know, because for some places, in some places, you realize that they are paid piece rate. They pay you for what you've done. So they never pay you for what you've not done. So if today I'm sick and I don't show up, then there is no pay for me. Is there any way that all these are now condensed into a law that even when I'm in hospital, I'm supposed to be paid?
It depends on to what extent. I mean, in what capacity are you working for that contractor? Are you permanently employed, or you are on a casual basis?
Yeah, we are basically talking about casual workers.
Definitely, there's still a lacuna, because casual workers are exposed to sufferings and a failure to benefit from areas where they would have benefited if they were permanent employees. For instance, the sick leave, I see no benefit that a worker gets when he's sick, that a casual worker will be taken care of, you know. So that's why the law is to the effect that we are getting to the place where we discourage casual work and make sure that people are given contracts so that they can be protected by the law properly.
Okay. Now talking about trade unions, we have people who subscribe to trade unions, but we also have those who do not subscribe to trade unions. One, because maybe they don't know that there is a trade union, that there is an umbrella that accommodates them, considering the nature of their work. Or some people just stubbornly don't want to belong to these trade unions because of maybe some of the financial implications they cause. But what is the way forward for all the two, for the workers in trade unions and those who do not subscribe to any trade unions? And what advice would you really give them?
As a person from the trade union, I would really want to encourage all workers to try their best to be sure that they are part of a trade union, that they are members of a trade union, because that is the easiest way of getting your issues addressed. Because you do not address your issues yourself, but you have gotten representatives that put your issues to your employer in a better manner than how you would have done it yourself. So it is a better and effective way of representing and addressing issues of workers. When we are in unions as workers, unions do represent our plight. Okay. Yes, so I do encourage workers, all of them, to be part of labor unions. The issue of subscription, it is a very small percentage, and besides, it is worth it because the benefits are so many.
Okay.
Yes.
So, what is your last appeal to both the workers and the employers, especially when it comes to creating a conducive working environment where both the worker and the employer will smile at the place of work?
My appeal, in as far as the relationship between the worker and the employer is concerned, in other words, the industrial relationship, okay? It is very important that we keep peace. It is very important that we mind about each other, that the employer, as a bigger arm, takes care of the needs of the employee and the feelings of the employee. Because I can assure you that when you take care of the feelings of the employee will in the same manner take care of your work or take care of your business. You take care of them and they also take care of your business. So it is very important that we find or devise means of maintaining peace and harmony at the workplace. Let the worker do their work. Do your work diligently. Do what you're supposed to do. Don't do what you're not supposed to do. Let the employer also do the same thing, you know. Let's look at the law as the middleman, that we need to be able to do the right thing so that we have peace at the workplace, so that the industrial relations are really kept in harmony. That is what I think.
Thank you so much, Mrs. Nabirye Susan, and thank you so much, you who started with us in the morning. We're back at 7 a.m. up to now. This has been Issues at Hand, brought to you by Protea Hotel by Marriott Entebbe. Edrine Osteen Mukalazi is my name. We meet at 9 p.m. with Flourishing Hub. God bless you. Meet again next time.